investigation. If you want to go to justice of peace, you need to have an information. You need to have make out a cognizable offense. Then only you would be able to get attention of justice of peace. Before embarking on that, cognizable offense define है 4K. If you happen to see CRPC 4K, it says Schedule 2. There is a CRPC का schedules हैं. Second schedule में there is a column whether it is cognizable offense or not. If it is a cognizable offense, then under 154, the competent officer, which is a police station जाते हो, then he is bound to register an FIR. Cognizable offense have been charted out, have been structured in the statute under CRPC 1898. And then investigation. This is also very relevant with respect to justice of peace making any decision. What is investigation? That is also defined. 4L है. इससे पहले 4K है, which deals with inquiry. Anything, inquiry क्या है? Anything done or conducted by the court other than trial. Anything done or conducted by court other than trial. वो इंक्वायरी है. जस्टिस ऑफ पीस क्या करता है? इंक्वायर करता है. Applies his mind, applies his cognitive skills, rationalizes the fact, prima facie tentatively assesses the material which is placed in the form of application before him. 22AB की दरखास्त देते हैं, and then he read out the content of that application, then applies, then inquire what other relevant material has been placed on record, evaluates, apply, and then he gives a decision based on own skills, analytical skills, vis-a-vis the report. If he has requisitioned that, then he may ask the officer to register an FIR against the proposed accused. It's not the accused. They are the proposed accused. And then inquiry start with the justice of peace, and then it led to what? Investigation. It led to investigation. Officer register an FIR against the proposed accused. He summons them, calls them, join the inquiry, and then once again वो सारा threshing का process है जो वो होता है investigation. और investigation क्या है? Investigation, anything done by an officer, anything which is conducted by the police officer other than court. कोर्ट से बाहर जो होगा investigation होगी, कोर्ट के अंदर जो होगा इंक्वायरी होगी. ठीक है, वो मैजिस्ट्रियल कोर्ट्स हो, वो मैजिस्ट्रियल कोर्ट्स हो, या ऊपर वाली सेशन की हो, या जस्टिस ऑफ पीस हो, then they inquire about the matter. And if it comes out of that court, then it goes to the officer. He would investigate it. Investigation is what? Collection of evidence. Evidence is what? Collection of material, real number of kinds of evidence, information, real evidence, forensic evidence, name the types of the evidence we got in law of evidence. Some other day कहीं इंशाल्लाह के मौका आसफ भाई ने दिया तो एविडेंस पे भी बात करेंगे. We move on. 4L deals with investigation, and then section 6 of CRPC says what? It lays out the paraphernalia of the court structure in Pakistan. पाकिस्तान में कौन सी कोर्ट्स हैं? मैजिस्ट्रियल हैं, फर्स्ट, सेकंड, थर्ड, एंड देन सेशन. दीज आर द लोअर कोर्ट्स, ट्रायल कोर्ट्स हैं जो. सेक्शन 6 आफ्टर 2002 it was added कि जस्टिस ऑफ पीस की होगी. It has to be read with the section 25. सेक्शन 25 उसमें अमेंडमेंट की गई और जस्टिस ऑफ पीस को उसमें डाला गया. सेक्शन 25 के तहत जस्टिस ऑफ पीस बनता है. He has all the powers. एंड देन वी मूव ऑन. जैसे 22AB पर आप जाएंगे. 22AB की पहली बात क्या है? इट हैज़ ऑल पावर्स ऑफ हु? द इन्वेस्टिगेशन ऑफिसर. सेक्शन 54 एंड 55. ही मे अरेस्ट. ऑफिसर 54 क्या कहता है? Officer can arrest in all cognizable offences and already mentioned cognizable offences क्या होते हैं? जो शेड्यूल में आ गया वो cognizable offence बन गया. अब हम obviously practice भी करते हैं सुप्रीम हाई कोर्ट एंड लोअर कोर्ट्स में. अगर if there is no mention whether it is a cognizable offence or not cognizable offence, then what to do of those offences? क्या FIR रजिस्टर होगी या नहीं होगी? सो उस पर कराची की एक जजमेंट मुझे रात को मिली 2005 की. आई वुड शेयर विद यू गाइस. इफ 3 साल से ऊपर सजा चली जाए देन इट इज़ द कॉग्निजेबल ऑफेंस. वो FIR रजिस्टर करें. इफ इट गोज बियॉन्ड 3 year सेंटेंस देन get registered an FIR against the proposed accused and bring him to the law. There are 4 basic things. There are 4, say, pillars how you can initiate criminal proceedings. Number 1. समझ आ रही है? Am I comprehensible? और उर्दू पंजाबी मिक्स चल रही है for your convenience. And then how to initiate criminal law machinery. Number 1, get registered an FIR. Go to the police station. Ask a person who is there to register your FIR. That could be in the form of oral assertions. That could be in the form of written application. And the word shall has been mentioned in 154. The word shall has been mentioned in that. He is bound to register your FIR against a person. And if he refuses, in many cases he does. And then what other remedy you got? Come with a private complaint. इस्तगासे के साथ हैं. इस्तगासे की पावर्स किसके पास हैं? 190. इसमें 4 ऑप्शंस दी गई हैं. रेड विद कॉग्निजेंस अंडर, वो एग्जामिन करेगा on oath under section 200, under section 200 के तहत इस्तगासा बोलेगा. इस्तगासे में he can take oral assertions आपकी लेंगे. इस्तगासा on oath है. It has to be on oath. If it is an oral form, he would reduce it. Magistrate would reduce it into writing. Get your signature, get his signature, he would mark it. रखना है रख लेगा, नहीं तो भेज देगा. He would take cognizance. अगर उसने dismiss करना है, if he dismisses it under 202, he may dismiss it. Cognizance based on what? Magistrate takes cognizance on the basis of what? Sufficient material. It has to be sufficient material. You places your oral assertions based on evidence. Evidence, number of types of evidence. Oral assertion आपने कर दी, medical आपने लगा दिया, और कोई डंडा सोटा कोई बीच में, और additional evidence if you got. Then relevant material, sufficient material, he would take cognizance of that and then proceed in accordance with law. If there is no sufficient evidence, then he would dismiss under 203. 203 के साथ उड़ा देगा. And then you file a revision before the High Court if you like. If you know, then it means you are satisfied with the decision of the court. Second, private, and third, justice of peace. Justice of peace, इसकी बहुत vast powers हैं. ये basic हमारा topic है. Power to arrest. 22A basically deals with the power of arrest. For you, मेरे पास तो सारे इसके notes बने हुए हैं, and I can go by section. But I think आपका focus और ध्यान के लिए I will divide into two main heads. It deals with the arrest of the person. It deals with the arrest of the person. ए जो है द पावर टू अरेस्ट ऑल पावर्स ऑफ द आईओ, जो आपका ऑफिसर है इसके पास वो सारी पावर्स हैं to arrest or cause somebody to be arrested. For that sake, he can approach the nearest police station, seek their assistance, guess उनकी arrest बंदे की, he can cause the arrest of the person. Who is what? उसकी भी आगे 4 या 5 किस्में गई है. The person who is required, the person who is trying to escape, who is trying to escape or abscond. For that, as I already said, he can seek the assistance of police in a local area for the arrest, prevention, and then law ये कहता है कि जस्टिस ऑफ पीस के पास सारी अरेस्ट के रिलेटेड वो पावर्स होंगी जो उसकी कॉम्पिटेंट अथॉरिटी के पास थी. सेक्शन 4 यही बेसिकली कॉम्पिटेंट अथॉरिटी से इनका डील करता है. A4 जैसे डीपीओ से इंस्ट्रक्ट कर रहा है, डीएसपी कर रहा है, एसपी इन्वेस्टिगेशन, जो भी उसका अपर टीयर में उसका बॉस है, द कॉम्पिटेंट ऑफिसर, he would act like a competent officer for the low person who is in police, obviously the nearest police station. So the point is he can cause arrest of an individual who is required. For that purpose he can seek assistance. देन दूसरा पार्ट जो है इसका डायरेक्शन से है. सेकेंड पार्ट गोज डाउन विद द डायरेक्शन. किसको डायरेक्शन कर रहा है? द पर्सन जिससे वो अग्रीव्ड है, इंडिविजुअल. सबसे पहले पार्टी किसको रखते हैं हम? पुलिस को, एसएचओ को, उसके हेड को, डीपीओ को, इन लोगों को रखते हैं. डायरेक्शन क्या है? डायरेक्शन, दिस आइडिया ऑफ डायरेक्शन हैज बीन ड्राइव्ड फ्रॉम mandamus, writ of mandamus. 5 types of writs. First is mandamus. Second most important, certiorari. These are the, एक जस्टिस की मैं कोट पढ़ रहा था, उसने कहा these are the flowers from heaven to redress the grievance of individuals. कोई काम कर नहीं रहा, अगर कोई कर दिया है तो वो गलत कर दिया है. So mandamus directs an officer to do certain things. अगर उसने कोई गलत कर दिया है, then it comes under the head of certiorari, that illegal order has been passed by somebody. Certiorari predominantly deals with orders. It may be judicial orders, it may be executive orders. Judicial orders been issued by who? These guys, the judiciary. It could be magisterial, it could be session, The justice of peace is not a court. He goes to what? Remedy guard is not a revisable order. It is not it doesn't come within 561A jurisdiction, inherent powers of High Court. It doesn't come in that. Number of judgment, reported judgment, and this point of law that it is not a judicial order. So you have to go in, 22 से भी आपके खिलाफ हो गई. Then go to the High Court under 199. If you are advised by your lawyer or yourself, go to High Court, get a direction to the DPO or the concerned to get register your FIR, first version, and then set the machinery of law into motion. Move on with that. Direction 2, it says 6.1 registration of the case. It deals with registration of the case. हमारे सिस्टम में, क्रिमिनल जस्टिस सिस्टम में, जैसे CRPC और PPC ऑफेंसेस हैं, ये बेसिकली आम सिस्टम में हमारा जो पैरेलल पीनल सिस्टम इसमें आते हैं. बट देयर आर स्पेशल लॉज जहाँ पे जैसे FIA है, ड्रग है, एंटी करप्शन है, इंटेलेक्चुअल प्रॉपर्टी राइट्स की है केसेस. These cases, justice of peace has all powers to direct the competent officer, even in anti-corruption and FIA, to register an FIR against the proposed accused for the redressal of your grievance. That is an issue. बेसिकली इशू सिविल में भी होते हैं और क्रिमिनल में भी होते हैं. इशू होता ही नहीं है जब आपका राजीनामा हो जाता है. सो आपका इशू आया क्रिमिनल साइड पे, you come to justice of peace, get a direction, seek a direction for the redress of your grievance, and then the machinery of law is set to move on. It will try all the tools which it has in its armory to help, to support, and dispense justice to individuals like you and myself in order to create peace, in order to create law and order, in order to develop a prosperous society, which unfortunately we're not having at the minute. And then move on to the second issue. रजिस्ट्रेशन एफ एफ आई आर पे कुछ और मैं आपको चीज़ें आपसे कर दूं. यू कैन नॉट मूव एन एप्लीकेशन थ्रू पावर ऑफ अटर्नी. बंदा बाहर बैठा है, मेरे बिहाफ पे पर्चा करवा दो, इट्स नॉट पॉसिबल. Law doesn't prohibit, law prohibits that. How you can initiate civil proceedings through power of attorney, but you cannot proceed in criminal proceedings against an individual. You have to be here. The aggrieved, the bereaved person should be here to initiate these proceedings. Then, transfer of investigation by one officer to another. अब यहाँ पे both sides पे judgments हैं. Whether Justice of Peace के पास एक application जाती है, आईओ ने investigation की, conclude किया, he is not cooperating with complainant side, prosecution side, then whether the Justice of Peace has power to transfer investigation. Answer is no. All he can do, if you are aggrieved of the investigation by the officer, then file an application under section 62A subsection 6 clause B. File an application. He would tentatively assess where is the mala fide, where is the wrong done. He would hear both the parties. इसमें हालांकि 22 ए भी में नोटिस समन्स नहीं होते रिस्पोंडेंट को, आप पढ़ेंगे, प्रैक्टिस में भी नहीं है. एनीवे विच whatever material has been placed before him through that grievance petition, he would give his own finding कि तफ्तीश ठीक हो रही है, गलत हो रही है, मिसगिविंग्स हैं, गलत साइड पे जा रही है. He can recommend to the SP investigation कि this is how your officer are doing wrong, and then appropriate forum is 18(6) का police order. For the transfer of application, you have to move an application to the concerned police officer. वो डिस्ट्रिक्ट स्टैंडिंग बोर्ड बने या फिर ऊपर जाए, DIB में जाए, डिवीजन इन्वेस्टिगेशन बोर्ड में जाए. So he cannot change investigation for one person to another. This is settled.